Good evening, everyone. My name is Frank Hicks, and I've been invited to chair this evening's CPD, an offer which I accepted readily and was more than happy to do. I'm here hosting two brothers, Rodrigo and Hernan Pintos-Lopez, and they're going to be talking to us today about class actions, the changing landscape of class actions following the recent High Court decision of Lend-Lease and Palace, and further the question of whether or not class actions will emerge in other areas now that there is a new statutory tort of privacy, and in particular will that give rise to class actions in a digital world given the risks of data breaches and other problems. So without further ado, I'd like to introduce Hernan Pintos-Lopez. Hernan is a barrister here at Greenway Chambers. He has a strong class actions practice, having acted in the Ruby Princess proceedings in the federal court and numerous bushfire class actions since 2014. He's currently acting for the state of New South Wales in a major human rights class action, but he also practices in other areas including negligence, inquiries and construction. So Hernan will be telling us about the recent High Court authority and the changing landscape, and I'll invite him to the podium now. Thank you very much.
Thanks very much, Frank. Yes, as Frank explained, I'm just going to be talking about, just want to start by making some observations about what's been happening in the class actions landscape, because I think, as far as I know, I haven't seen a lot of commentary about it, but it is actually very interesting, I think. So I'll start with that overview of what's happening. I'll talk a little bit about the class actions legislative framework and how it works, and that provides some of the background to the Lend-Lease decision in the High Court, Lend-Lease and Palace. So one of the key things to note is that last year there was a very large number of class action filings, 79, up from 46 in the previous year, and that included 28 consumer, 25 employment, and 13 government liability class actions. Now, what's significant about that is that the number of, there were only some 8 class actions in relation to securities and 1 for financial products. So there's been such a change in the last decade where previously the securities class actions dominated, and now it's very strongly the case that consumer class actions are dominating. And the thing which is interesting is that there's been a growth in employment class actions, there's been a diversification of the sorts of consumer class actions that we're seeing, and there's also been, so for example, in consumer you can see that there are issues around supermarket pricing, after-sale electronic warranties, from electronics retailers, cold and flu medication, various health type, very diverse. And what this demonstrates is actually something pretty fundamental about class actions, which is that it's really just a procedural framework. A class action can be about anything as long as you've got commonality of the claims. So that's quite important. And what we're seeing is very much a real entrepreneurial surge, as it were, of different solicitors and funders developing class actions and putting them forward and finding people who've been affected and running cases. Now, last year there were 30 class action settlements totaling about $1.9 billion, which is a very significant amount of money. And of those, some 7 of those were more than $100 million each. And that included 2 stolen wages cases, which brings me just very briefly to the government liability space. So I'm currently doing, as Frank said, a human rights class action, and we're seeing a lot more of those sorts of actions occurring. Stolen wages, youth detention, all those sorts of things. And that's a very big change. So previously we had a lot of securities and financial products. Now much less. And I don't think there's been a lot about that. So as I say, the thing to note there is the entrepreneurial nature of class actions. The second is the neutrality of class actions as a framework. And the other interesting thing to note is that in many areas, Australia follows the US. Australia is seen as having a very open, permissive approach to class actions, but often people here are inspired by what's going on in the States. They see class actions running in California, in New York, and they see if they can get them off the ground here. So that does change the way things work in Australia. So I just wanted to touch on some things here, just moving on to the class actions framework. I just want to touch on some features that, a lot of this is very introductory, and I find that, for some people who already practice in the area, a lot of this might be terribly basic, but I think it's important for those who don't practice in the area or who are interested in the area to understand some of the features of it. So the first thing that makes a class action is that you have to identify at least one common issue of law or fact. The second thing is that the group members must be described, but they don't need to be named and they don't need to consent to being part of a class action. So the court has to fix a date by which group members can opt out, and these are all features of Part 10 of the Civil Procedure Act in New South Wales. But the Civil Procedure Act also is very substantially identical to Part 4A of the Federal Court of Australia Act. So it means that there's real commonality in the framework between the federal scheme and the New South Wales scheme. Now, the key reason why people bring class actions is that when the court determines the common issues, answers the common questions, all of the group members are bound unless they have opted out. And the way in which it's set up is the hearing, unless the court orders, the trial cannot commence before people have had a chance to opt out. Now, there's also part of the legislation, which is the part that Lend-Lease deals with, is Section 175, that provides for notices to be sent to group members. And that's important because the scheme provides for certain notifications to be provided, particularly in relation to some of the key things, including when the proceedings are commenced, and also so that people know when the date to opt out is, when that's determined. So that's Section 175, and we'll get to that in a moment. But also, it's probably good to have a bit of an understanding of some of the terminology that gets used in the cases around class closure. An open class is basically a circumstance where there are members of the class who are caught by the definition, but they don't know that they are members of the class. And everybody would have seen, probably at some point, an advertisement or something in a newspaper saying, if you bought shares in this product between this date and this date, you might be a member of the class. Those are the sorts of, and the reason why those sorts of notices are given is because you can be a member of the class and caught by the definition of it without knowing and without coming forward. So that'll be a key thing that we'll come to in a moment. Now, a closed class is where the class membership is defined so as to identify all of the class members. And there are some cases where within this framework you can commence proceedings, but with a finite number of members of the class. So you can, for example, as they did in Ferry, provide a schedule that lists all of the class members. Now, Ferry, interestingly enough, was a case where they sought leave to open the class briefly to register more people and then close it again. So that was an unusual case. Now, you'll also hear references to two other concepts that come up in the cases, and the first is soft closure and hard closure. And so basically the difference between those two is that hard closure is that you're not entitled to share in the benefits of settlement unless you are registered, and soft closure is where the court makes a time-limited order to promote settlement and mediation and settlement, but it's time limited. If you register within a certain time, you can share in the proceeds, any proceeds of settlement that might come from mediation. But if you don't register, and if the matter doesn't settle, then it's as if there was no order. The order simply ceases to function. Now, I won't spend very long talking about Justice Lee's observations in Gill and Ethicon, but the short point to come out of that is that there's real doubt, particularly from very experienced class actions judges such as Justice Lee, to the effect as to whether it would ever be appropriate to order hard closure when there are lesser options like soft closure, which is much less problematic. So that's a key feature of what's going on. So that brings us to Lend-Lease. And Lend-Lease was basically a case about a separate question. Separate question was formulated, was referred to the New South Wales Court of Appeal, and it was a securities case. It was a case which alleged misleading deceptive conduct that affected some 400 odd million shares that had been bought in a period of about a year in Lend-Lease. Now, the issue in that case was whether or not the court has power under section 175(5) of the Civil Procedure Act to order that notice be given to group members of the defendant's intention if the proceeding is settled to seek an order providing for class closure. So that was the issue, whether the court could give the notice of that the defendants in that case, and possibly the plaintiffs, would seek an order to that effect. Now, the New South Wales Court of Appeal answered the question in the negative, and an important part of the reasoning in that case had to do with essentially, we might just actually touch on first on the provisions, and then I'll get to why the Court of Appeal did what they did. So you'll see that section 175 of the Civil Procedure Act provides for the giving of notices to group members, and in particular the issue is all about 175(5). The court may at any stage order that notice of any matter be given to a group member or group members. And many different judges formed many different views about whether or not the notice could or could not be made within the definition of, within the scope of 175(5). And you'll see also the reference to an event in 175(6). There was a divergence of views about the extent to which the word event conditioned the power to give a notice. Now, not the most exciting topic in the world, but it is a topic of great import in class actions for reasons that we'll get to in a moment. And you also see section 179 of the Civil Procedure Act effectively means that when judgment is given, all group members are bound unless they've opted out. And that's the thing that really makes class actions work. It's the binding of all of the group members, irrespective of whether they know it or not, that really makes it work. All right. So in the Court of Appeal, Court of Appeal held that the court did not have power to order the notice that was sought, and the bench was comprised of Chief Justice Bell and Justices Gleeson, Leeming and Stern, and President Ward, who agreed in the orders but did not agree in all aspects of the reasoning. Now, really just want to touch on this very briefly. There are really four aspects of the reasoning, but the first and most important is that in the Court of Appeal, they very much were of the view that the giving of the notice that was proposed, the proposed order, was contrary to the fundamental idea that a group member should be able to be a group member without having to take any steps in the proceedings in order to obtain the benefit of settlement or judgment. and also that providing the proposed notification would essentially lead to a conflict of interest between registered group members and unregistered group members. So the idea being that the lead plaintiff, or plaintiffs in this case, could not properly represent the unregistered group members when they intended, in fact, to seek an order that would terminate their rights at the end of a mediation and settlement. Now, their honours held, with the exception of President Ward, that Section 175.5 is constrained by Section 175.6 and that must relate to an event that has happened. And in this case, the proposed notification simply related to an intention on the part of Lend-Lease and not an event. Therefore, it was not within power. Now, there was also some divergence based on there had been a previous Court of Appeal decision in a case called Wigmans, and the reasoning in Wigmans was followed in Palace in the Court of Appeal, but it was disagreed with in a full federal court decision in Parkin. So the question was a conflict of authority between the full federal court and the Court of Appeal, and the Court of Appeal considered that Wigmans was not plainly wrong, and that there weren't compelling reasons not to go follow that earlier authority, a recent authority, in fact, of the Court of Appeal. So the matter goes to the High Court, and there was a contradictor involved because basically both parties who were in the proceedings were agreed that there was power. So the court had, in fact, the Court of Appeal had appointed a contradictor, and the contradictor was arguing also in the High Court. There are 4 judgments, a judgment of Chief Justice Gageler and Justices Gleeson and Jago in the High Court. I've just highlighted some of the aspects of their judgment, but the key thing that I think various of the key points are that, firstly, there's always a potential for inconsistencies in the statutory scheme, and that's something that just has to be managed by the court. So the potential for conflicts of interest is not, in their view, fatal to the proposed notice. And the purpose of Section 175.5 is to give group members notice of things that happen in the class action. So that power should be interpreted broadly. Just skipping over, basically their honours found that encouraging group members to register their participation for the purpose of facilitating settlement doesn't transform the scheme from an opt-in scheme, from an opt-out scheme into an impermissible opt-in scheme. So that's a key part of the reasoning here. Now, there was also a decision of Justices Gordon and Stewart who also agreed that there was power to make the notice, and really their view was that the word matter was wide enough to cover the order that was proposed, and that event was not an issue. So as a matter of construction, there was no difficulty. But the key part which is interesting here is picked up at point 2 there, which is that there was no dispute between the parties that the court in fact had the power to make the order for class closure at the point that it was necessary to do that. In other words, if you had a mediation and there was a settlement, there was no dispute by anybody that the court would have the power to make the order to close the class, with the effect that that would have on all of the class members. So this is a key part of the reasoning, and I think is probably the most persuasive part of it, which is that it would be contrary to the purpose of Section 175.5 if the court had the power to approve a settlement that excluded unregistered group members, but didn't have the power to inform group members of the intention to seek settlement on that basis. So you have the power to make the order, but you don't have the power to tell the group members about it. and they held that that couldn't possibly be the scheme. Now, they also went on to suggest, in similar fashion to the plurality judgment that we covered earlier, that the managing of conflicts is just a normal part of class action practice. The court will often have circumstances where it needs to impose conditions. The court is involved in approving settlements, so the court has a very important role in terms of protecting the interests of unregistered group members as part of that process. And there are many other ways in which the court can deal with potential conflicts. Now, Justice Edelman also gave a judgment, but I won't deal with it here because Justice Edelman's judgment was largely about how intermediate courts of appeal should follow authority, how they should deal with conflicts of authority between different courts. And that's a very interesting topic in itself, but not the topic that I'm focused on. And you'll see also that Justice Beach-Jones also agreed with the other judgments delivered in the High Court about fundamentally that there was power to issue this kind of notice. Now, finally, I'll just explain why it matters. So it is a very narrow question of statutory construction of one section of an act, but why it's important is because there's been a move away in recent years from orders that seek to notify people that if they don't register, they will, by reason of not registering, be excluded from sharing in the benefits of settlement. Now, those sorts of orders were found not to be available in an earlier case called Hazelhurst in the Court of Appeal. So now the approach is, first of all, you send out the notice to say, we intend to seek an order on this basis. So if there's a settlement and you haven't registered or opted out, you don't get to share in the benefits. The reason why it's important is because part of negotiating, particularly for a defendant, is trying to price the size of the class. What are the outstanding claims? What are the value of those claims? And how many unregistered people are out there? Trying to work out whether or not there's more claims in what's referred to as the tail is a very difficult part of trying to deal with class actions. So getting people to register promotes certainty both for plaintiffs and for defendants. Certainly defendants want to know how big the class is and how much they're paying per claim, in effect, to settle. That's key. So importantly, what we see here also is that in the judgment talks about the fact that most securities class actions are resolved by settlement. And certainly my experience and observation is that most class actions generally, not just the securities ones, are resolved by settlement, by negotiation. So what you see, the High Court decision in Lend-Lease is effectively support for an approach that recognises that the purposes of the Act are served by facilitating resolution, whether by settlement or judgment. And settlement is an equally important aspect. So I'll leave it there. If there are any questions, we'll touch those on those at the end. But I might hand over to Rodrigo to talk about the interesting question of the new statutory privacy tort. Oh, right, thank you.
Hernan is, as I understand it, the elder brother, so it's not probably surprising he didn't want his younger brother to have any sort of introduction. But notwithstanding that desire, I'm going to give him one anyway. Rodrigo joins us from the Victorian bar, where he is a member of the List A and he's a commercial barrister. We're very pleased that he could join us here in Sydney to talk upon this topic. He studied at the University of Melbourne and also Harvard Law School, and spent a number of years working in the salt mines in New York at Cravath, Swain and Moore, where he was telling me earlier that an 80-hour week was in fact standard, and if you could not come in on Saturday, then don't bother coming in on Sunday. Rodrigo does general commercial work, including regulatory and insolvency work, has acted in many class actions like the NAB Banks fees and derivative class actions. He's here to tell us about what might be emerging as a result of the new statutory tort of privacy in the field of class actions. Thank you very much, Rodrigo.
Thank you, Frank, and thanks, Hernan, and thank you, Greenway Chambers, for allowing me to come and talk to you about a topic that interests me, which is the emergence of a statutory tort of for breaches of privacy, and how that might find a way into class actions, particularly for data breaches. And it's been interesting to watch because the tort commenced in the middle of last year, but I think there's a bit of wait and see happening from funders and from plaintiff class action law firms to see who's going to move first, because there's a certain amount of uncertainty about how you might plead a case, a class action for breaches, data breaches. And so I think it's very topical. It follows on from what Hernan was saying. It's been my experience that the continuous disclosure type cases have tended to shrink, and then the market has tended to broaden in class actions. And I think that data breaches is an area where there's great interest for a number of reasons. Right? One, because class is easily ascertainable. You've got a common issue of fact, and they're probably very high value claims, particularly with large corporates like Optus and Medibank, and you've got Qantas data breach from last year that was significant. So and also I think data breaches cover a number of sectors, right? It's not just it's financial services, it's energy, it's aged care, and with the advent of AI, that kind of might throw a spanner in the works. It'll be interesting to see how these cases might proceed. So where we were prior to the amendments to the Privacy Act was that the data breaches were very attractive to funders and to law firms, but the process of getting a class action up for a data breach like Medibank and like Optus was a little strained, because you could either go to the federal court, and in the federal court those class action claims are problematic because you've got a mix of claims. You've got misleading deceptive conduct, you've got breaches of confidence, breaches of contract, negligence, but they don't really centre around the privacy interest, which is really the concern, or is, I suppose, the wrongdoing that arises in the context of a data breach, right? When there's a mass loss of financial information, credit cards, passport details, those kinds of things. And the other route was to go to the Information Commissioner and to seek under the representative complaint mechanism, to seek a determination. And that has its constraints as well, because it's limited to privacy principle breaches under the Act. There's exclusions to the Privacy Act. It's incredibly complex. And more importantly, those determinations are non-binding, and if you want to enforce them, you've got to go to the federal court where you have a hearing de novo. So the Optus, for example, and Medibank have a multitude of different law firms pursuing under the various channels for the same breach at the moment. So you have a fragmentation, I suppose, of claims under where we were before. The reforms to the Privacy Act did a couple of things, but importantly, in the context of the discussion of class actions for data breaches, the reforms brought in the statutory tort, which allowed for a direct cause of action for breaches of privacy, and now since the middle of last year, more recently, individuals can claim compensation where the Information Commissioner seeks civil penalty for breaches of the privacy principles under the new Section 180 UA, and that has some obvious limitations in and of itself, because you've got to wait for the Information Commissioner to seek a civil penalty against a company. It has to be breaches of the privacy provisions, privacy principles. So really, the hope of funders in Australia and plaintiff class action law firms will be on the development of the statutory tort in this space. The history of the tort is important because it will inform, well, for starters, it's a tort, right? The intention, the express intention of Parliament is that this tort will develop, it will be developed by the courts by reference to international developments, and also in the context of other torts. So the background, the extrinsic materials, the mischief of the tort will be relevant, in particular in terms of convincing the court that it ought to be applied in the context of the data breach. So you can say that Lena Game Meats kicked off a case called ABC and Lena Game Meats, which I wrote a very long paper on a long time ago, and I said there should be a privacy tort, when I was a law student, and thought that was a really good idea, and it never happened. But Lena Game Meats really opened the thinking, I suppose, in Australia to the idea of that there should be a privacy tort. We don't have a Bill of Rights. Privacy isn't protected in any other way, and that's really what happened in Lena Game Meats. There was some animal activists. They trespassed on a possum abattoir in Tasmania, and the court said, well, it kind of falls between stools, right? There's no confidence, and the company's real problem was as well that it had no privacy interest because it wasn't human. But the court really was taken to this development or developments in the UK where the discussion was whether the breach of confidence should expand to include privacy interest, or whether Australian case law can create and break off a new privacy tort. The court was reluctant to do that. And also historically, the US and the UK influence are important because they created some of the elements of the tort that we have in Australia. The real kickoff was a seminal article by Samuel Warren and Lewis Brandeis about the right of privacy, and then in the 1960s you've got William Prosser, who has categorised as a taxonomy of 4 different kinds of privacy tort, and we've opted for the first 2, which include intrusion upon seclusion and misuse of personal information. But that development comes externally from other countries, and is something that is expressly talked about in the explanatory memorandum. It's something that courts should have a look at in terms of how that tort is developed here in Australia. So the other important point about the relevance today is that the privacy tort is based on concepts of dignity and autonomy that are relatively foreign to Australian law, and that's why it supports claims for emotional distress, and that will be quite important to a funder and how you might plead a case in court for a breach of privacy, because how you quantify harm, emotional distress across a class will be an interesting question that needs to be resolved over time. So again, Australian courts will look at, so we have Lena Game Meats, and then there's a couple of Law Reform Commission reports that are seminal, 108 and 123. The 2014 report recommended the tort that we have now, right? The shape of that tort was set out there. And as I said, courts are expected to develop through cases and draw key concepts from other torts and international precedents. So the torts now contained in Schedule 2 of the Privacy Act, those are standalone provisions. So you're not to have regard to definitions in the Privacy Act, or in the body of the Privacy Act. It's a standalone scheme, effectively. And importantly, the explanatory memoranda tells you that there are a series of reforms to the Privacy Act, the privacy principles, the power of the Information Commissioner, anti-doxing laws, the individual right to under Section 80 UA, but probably the most significant development was really the addition of Schedule 2. And the context of the reforms is about personal data and mishandling, including through data breaches, fraud and identity theft, unauthorised surveillance and significant online harms. This was in the mind of Parliament, not only as they reformed, but as they enacted the new tort. So the elements of the tort, there's 5 elements. You have to establish that the defendant invaded plaintiff's privacy in one of those 2 manners. Intrusion upon seclusion is really about surveillance cameras, those kinds of things. So it's a different space. Or misuse of personal information. The person in the plaintiff's position would have to have a reasonable expectation of privacy. That's something that we picked up from the UK. There's a fault element, it has to be intentional or reckless. The invasion has to be serious, and ultimately there's a public interest balancing test which we pick up as well from the UK. Importantly, it's actionable without proof of damage, and as I said before, there are damages for emotional distress. So there's a cause of action if the defendant invades the plaintiff's privacy by misusing information that relates to the plaintiff. Misuse of information is defined as including collecting, using or disclosing information about the individual. And I suppose that's the first area of interest if you're going to plead a case, and probably one of the things that most funders and plaintiff law firms are waiting to see is how you might plead misuse of information in the context of a hacker. Because arguably the hacker is the person that's misused the information and Qantas is just holding the information. And so that would be an important threshold issue, as well as obviously how you establish recklessness in the context of a major corporate, which will be a question of evidence, really. Reasonable expectation of privacy. I'll walk you through these elements, but they're not, I don't think they're critical. I don't think that these are going to be areas of major contest in the context of a class action for a data breach. It's an objective test. Is this private? The court considerations include means and purpose, plaintiff's attributes, plaintiff's conduct, and importantly, the nature of information, intimate, health-related, financial. If you've got your credit cards, your passport details, your driver's license, it would be hard to say that that's not the kind of information that one would have a reasonable expectation of privacy of. So recklessness is as defined under the Criminal Code. Section 5.4, a person is reckless with respect to a circumstance if or result if he or she is aware of substantial risk that the circumstance result will exist or exists, and having regard to the circumstances known, it's unjustifiable to take that risk. So breaking that down, there has to be an awareness of substantial risk, and the risk has to be unjustifiable in circumstances known. Now, circumstances known is really important in the context of a case such as this. And the awareness of substantial risk, right? So you have to show that your corporate had an awareness of a risk, and you have to show that the risk was unjustifiable in the circumstances known. factual determination. This fourth element, that the invasion of privacy was serious, is an objective test. Ultimately, the extrinsic material says that it's there to prevent trivial claims. Factors for assessing seriousness: degree of offence, the defendant's knowledge or reasonable awareness of potential harm. The final point's probably the most important one in the context of a mass data breach. Like Qantas was over 5 million people. Right? Other matters may also be relevant. For example, the number of individuals affected. It'd be hard to say that a data breach of the size of Qantas's data breach from the middle of last year wasn't serious in that context, having regard to the number of individuals affected. And finally, there's a public interest balancing test, which is picked up from a case in the UK called Campbell and Mirror Group newspapers. The element is that the public interest in the person's privacy outweighs any countervailing public interest, and you have a list of public interest factors that are relatively unsurprising: media freedom, national security, public health and safety, those kinds of things. There's a balancing test there, and really, I suppose it's there to capture probably the smaller cases where maybe there might be an interest in terms of media freedom or national security. Those things get picked up again at the back end as well of the Act in terms of exemptions. And finally, there's the damages. As I said, it's actionable without proof of damage. You can get damages for emotional distress. Importantly, there are damages for exemplary or punitive damages to deter future conduct in exceptional cases. You can see a court having found that all the elements are satisfied in relation to a data breach would, in certain circumstances, you can imagine a court with the right kind of evidence finding that there ought to be punitive damages to deter future conduct. There's caps. There's a connection to defamation law, which isn't relevant for the purposes of this talk, but that the damages are capped at a certain amount, or the defamation limits. Courts can consider apologies, corrections, all this kinds of settlement attempts to defend its conduct post-breach in assessing damages. Like I said, there's defences for the obvious: courts, tribunals, threats to life, defamation defences are included in there, and there are exemptions for journalists, agencies, state and territory authorities, law enforcement, intelligence. Importantly, and unsurprisingly, as the legislation was progressing through both the houses, there was a lot of lobbying from newspapers and news organisations, and so there's a lot of protection for journalists in various parts. We saw freedom of speech in relation to the balancing test, and now you see the exemption for journalists in certain circumstances. The limitation period is short. It's 1 year from awareness. It's the lesser of 1 year from awareness or 3 years from invasion. So if you've got a massive data breach, it's 1 year because everyone's going to know about it. Okay, which gets me really to the bit that's probably most interesting to me, which is how are these cases going to be pleaded, right? In a database breach, does the company invade the client's privacy by misusing information that relates to the client, by collecting, using, or disclosing information about the client? Or is it the company or the hacker misusing by using or disclosing? And I think really the way in which you would run a case like this is to focus on the word misuse, and which means as a verb to use something incorrectly, improperly, or for a purpose other than that for which it was intended. And the formulation at the end would really be that the company's holding of the information in an inadequately secured system in a way that exposes it to exploitation is misuse, right? So misuse that results in another person misusing your information is also misuse. So it's the holding of the information in circumstances where you know that you have inadequate protections and that it's obvious that it could be easily exploited. So really the hacking in and of itself isn't relevant to that claim per se. It's the perfection of the claim. It might be relevant in terms of damages, but the misuse in the hands of a Qantas is really about how you hold that information. And the way that you would get there is by a question of statutory construction. And as I alluded to before when I was talking about the evolution of the tort, how it resulted from a process of law reform, supports a reading of the word misuse that would include a breach of a database and the disclosure of personal information, because the word includes in misuse, and the way it's defined is deliberately broad. The context, the mischief of the tort itself is revealed in the process of law reform explanatory memoranda. In fact, the Privacy Act review report of 2022 that kicked off the government's response, that kicked off the negotiations, that kicked off the explanatory memoranda, says explicitly at the beginning, the review has considered whether the Act and its enforcement mechanisms are fit for purpose in an environment where Australians now live much of their lives online and their information is collected and used for a myriad of purposes in the digital economy. While the digital economy has generated significant benefits, it has also resulted in large amounts of information about people being generated, used, disclosed and stored. The vulnerability of people's information in the digital age has been highlighted, including recently in relation to several high-profile data breaches exposing millions of Australians to privacy risks, including identity fraud, reputational damage and blackmail. So I think that there is a way home on the definition of misuse, notwithstanding the fact that the hacker is also breaching, is also engaged in wrongdoing, or more obviously engaged in wrongdoing. So recklessness, evidence of recklessness would include security risks left unaddressed, board papers, management communication showing awareness of risks, regulatory correspondence, repeated data breaches, and you would probably look to expert opinion on foreseeability and preventability, and industry standards and breach cause. So these are the types of things that would support the kind of claim that I've just outlined. And finally, on emotional distress evidence, which is probably the final part of it, I think there's three things I want you to take from what I've just talked about. One is that I think that the fight in terms of convincing a court to make findings in relation to a tort of privacy for a class action for data breaches is going to be in how you define misuse, how you establish recklessness, and finally this question of how you're going to show loss. And so those are the kinds of things that I expect we would be relying upon. And also finally, the example of evidence in personal harm torts, it's explicit in the extrinsic materials in terms of what Parliament intended the tort to do and how it expected courts to develop this tort.
Thank you very much, Rodrigo. That was a fascinating series of observations about the state of the world as we currently have it and the new statutory tort of privacy. Does anyone have any questions for Hernan or Rodrigo? Yes. Thank you. Sorry, we do have people watching us live streaming who may not have picked that up. Rodrigo, would you just like to come to the lectern and just explain exactly what the question was and how you answered it, please?
Yeah, so it's a great question, right? The question is Clause 7.2, which follows the Clause 7.1, which sets out the elements, provides that it's actionable without proof of damage. And the suggestion was that it might be that it's actionable, there might be a second phase in terms of damages. But I also think the relief you might be seeking might be an interim injunction, might be declaration, so you might not need to establish damage. That's the way I read it.
Thank you. You might just wait there for a moment, Rodrigo, because if no one else has a question for you, I do. In this, I'm not particularly familiar with the statute of statutory tort of privacy. Yep. I'm also not particularly familiar with technology. Yes. I'm a very analogue person in a digital world. So forgive me if my questions seem a little bit rudimentary, but obviously one of the things that plenty of people are concerned about at the moment is not just data breaches, but the actual collection of information and data farming that can occur through people such as Facebook, TikTok, Instagram, all these sorts of things. And I did notice that one of the concepts of misuse was the simple collection. I don't want to necessarily give funders or solicitors any ideas, but is there an option for a class action against Facebook in respect of the way in which they skim your data, observe your searches so as to acquire information, which obviously they then monetize in terms of their business practices? But I mean, is there a potential there for some sort of class action?
Absolutely. And Hernan and I were talking about this earlier. It extends the definition of misuse is using a thing in the wrong way or for a purpose for which it was not given, right, in this case. And it not only applies to your example of Facebook, but also major corporates that hold masses of information for a lot longer than they need to, after that the purpose for which you've given it has expired.
So, for example, Bunnings employing face recognition.
Well, that's an interesting question.
Well, I don't know. I mean, this is where all these things are going, isn't it? That there's this level of surveillance and recording in terms of what who we are as a matter of individuals, but also in an electronic or digital way. And it just occurred to me that this is, at least on the statutory books, on one view of the legislation, an option to perhaps draw a line in the sand in respect of that sort of stuff.
Well, what about a large model AI that scrapes all of your information? Is that a misuse? Probably is. Probably is. You certainly don't give your information to Bunnings. Right?
No.
I have an account.
I buy a sausage.
To buy a sausage, that's right. To be used by an AI bot.
I had one more question for you as well. You may see it in my notes. I'm interested in this whole notion of journalists being protected and invasions of privacy. Does that mean there may be a class action available for allegedly dodgy tradies who have had foot in the door journalists, interrupt them and sort of stick microphones in their faces and those sorts of things?
I think that if there's anything that's clear about the tort, is that journalists are a protected class.
Maybe a good thing. All right. Well, that just about brings us to 6:30, unless anyone has any...
I just have one.
Yes, please, go ahead.
Am I right to think that Australia's tort more dictated by UK principles of privacy than the US?
So there are a couple of. So the answer to that is yes.
Generally speaking.
Yes.
Yeah. I mean, just interesting to hear Hernan say that the class action landscape's been in Australia's been formed largely by what happens in the US, but I'm hearing from you that maybe privacy is slightly more to the UK.
Or think, well, PROSA, so yes and no. In relation to various of the elements, yes, direct take from the UK. In relation to the torts themselves, the US led a long time ago. They, that article turned into effectively the creation of the tort. So the article from the 1890s, and then there was major development. You have academics like Prosser who categorises the four and is referred to, constantly in terms of the authorities in the United States. So maybe a bit of both.
All right, well, it just remains for me to ask you to thank Rodrigo and Hernan in the usual way. And thank you everyone for joining us, and that concludes the CPD for this evening. Thank you.